You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 30, How to Speed Up Your Patent Application Examination. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or you can call me at 424-281-0162. While most attorneys can only practice in states where they are members of that state's bar, patent attorneys are actually allowed to practice patent law for clients in any state. So feel free to contact me regardless of where you live. We're almost to the episode of how to actually submit your application to the patent office. But there's one last topic I want to go over before you file your application, and that's how to get your application to be processed faster. A lot of people ask me, how long does it take to get a patent once they file the application? And I'm going to give the answer that every attorney gives whenever they get asked a question. It depends. But really, it does depend on a lot of factors. I've had applications that get an allowance in 3 months. I've also had applications sitting in the patent office for 2 years. The latest numbers that I've seen says that the average time to get a first response from the patent office is 16 months. When you file your application, it gets put into what's called a technology group. For example, molecular compound applications are sent to a different technology group than, for example, hamster wheels. And different technology groups have different backlogs. So there might be a backlog of only 8 months in one technology group, while another technology group may have a backlog of 2 years. And this is just to get your first office action, which is usually some type of a rejection. Then after that, there's usually some back and forth between you and the patent office before it gets allowed, if it gets allowed at all. So we're generally talking 2 to 3 years to get an allowance on a patent if you actually get one. So let's say you don't want to wait that long. What can you do to get it examined faster? There are a few different ways that we can do this. One is called the Prioritized Patent Examination Program. It's also called Track 1 for short. This is the easiest way to get it examined faster. Basically, you pay the patent office to move your application to the front of the line. Currently, it costs either $1,000 if you're a micro entity, $2,000 if you're a small entity, and $4,000 if you're a large entity. I covered what qualifies as a micro entity, small entity, and large entity in a previous episode, so go back and listen to those to see if you might qualify. These are the fees that you'll see if you look it up, how much it costs on the patent office website, but it's a little misleading because you still need to pay a patent office processing fee. And you might see that in the fine print, but it's easy to overlook. Lots of things at the patent office require a processing fee alongside the fee for what it is you actually want to do. The processing fee currently is $35 for a micro entity, $70 for a small entity, and $140 for a large entity. So the total patent office fees you'll have to pay to request Track 1 is either $1,035, $2,070, or $4,140. There's a form that you have to fill out that you can find on the patent office website, and it's form AIA 424. You put in your name, title of the invention, check the box under original application because that's probably what you're filing, and you print and sign your name at the bottom. The goal of this program is to get your patent allowed in 12 months. Right now, the average for a first response is about 4 months, and a couple quick back and forths you might be able to get allowed in 12 months. There are a few requirements that are pretty basic and not usually an issue, and if you want to know more about the details, just search the Patent Office website for Prioritized Patent Examination Program. Technically, only 10,000 Prioritized Patent Examination Program applications are allowed per year. So, in theory, if you try to do this at the end of the year, there might not be any slots available, but I haven't come across that problem, and I don't think the Patent Office currently maxes out on the 10,000 application limit. Another option is called accelerated examination. The main difference between accelerated examination and prioritized examination that I just talked about are the additional filing requirements for an accelerated examination. You're required to do a pre-examination search for each of the claims. You have to say the databases that you searched and the searching methods that you used. And you have to disclose all the relevant references. You have to say which references most closely related to the claims, and you have to say why each claim is patentable. You're also required to have an examiner interview, which isn't a big deal because examiner interviews are actually pretty helpful to get your patent allowed. The fees for this program, the accelerated examination, are lower. It's either $35, $70, or $140 depending on your entity status. But it usually takes an attorney a significant amount of time to prepare all of this, And those costs are probably going to be more than the cost that you would just pay for the Track 1 program. And plus, in the Track 1 program, you don't have all these requirements of what you need to submit. So in general, I would say it's not worth it to do the accelerated examination program. Another option is called the Patent Prosecution Highway. This won't apply to you if you're filing your first application in the United States. But if you filed a foreign application in certain countries on the same invention, and it's been allowed, you can jump to the front of the line for your U.S. application. There are no fees for this, so there's probably no reason not to do it. But if you haven't filed a foreign application or an international application called a PCT, then this won't apply. There are a few other ways to get your application examined faster, and that's if you file something called a petition to make special. There are some categories and types of inventors that the Patent Office believes are important, and this will bump your application to the head of the line. Sometimes it's pretty automatic and will get bumped in the front of the line, but other times it's possible that your petition to make special could be denied. If any of the inventors are 65 or older, then your application can be made special and your application jumps in the front of the line. If you have ailing health and might not be able to assist with the prosecution of your application, then it can also be made special, but you'll need some type of corroboration from a doctor. Also, if your invention materially enhances the quality of the environment, development of energy resources such as hydrogen fuel or nuclear or solar energy, you can jump to the front of the line. If your invention is about countering terrorism, you can also have your application made special. There's no fee if you want to petition to make your application special under these scenarios. You can also have your application to be made special if it's regarding HIV, cancer, superconductivity, recombinant DNA. And there's another scenario where you can petition to make special if your application is the subject of some litigation. But there is a fee in this case, and it's currently either $35, $70, or $140 depending on your status. There are lots of details about filing a petition to make your application special and accelerated examinations. So if you're interested in this approach, you can search the Manual of Patent Examining Procedure, Section 708. Filing a petition to make special is something to consider if you fit into one of the categories. And if you don't, you might think it's worth it to pay just $1,000 to $2,000 to get it examined quickly, especially if you think from a business side, there's a really high chance that your invention will get a patent, and having an enforceable patent as quickly as possible might help your business because you can start getting royalties sooner. Now, what I've talked about so far in this episode is how to get your application bumped to the front of the line, and that's one way of getting your patent examined quicker. But getting your application examined quicker is only one part of getting your patent allowed quicker, which is probably the goal of what most inventors want. It doesn't matter if you get your patent application examined quickly, if it's written poorly, and you don't respond well to the examiner's rejections. If you want to get your patent allowed faster, you should have a well-written patent application, respond quickly to examiner comments, conduct a patent examiner interview to find some common grounds where you can get a patent, and know how to amend your claims to get an allowance. I'll cover the details of these in future episodes. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.